Sue Nikora, White Claimant 222 and 129. Aka, Arikinui, Tapaidu, Ngakawengarangi Prime Minister, Maori Government, Aotearoa, New Zealand, commissioned by Sovereign Confederation of Chiefs of Tribes. Aka, Paramount Chieftain Patuedua of the Authority o Mana o Turanga, Gisborne. Aka, Paramount Chieftain Te Atau Otarangi o Ngati Porou. Aka, Senior Uri of Uepohatu through Rako Manawahe and Kari. I do solemnly swear on oath that I promise to tell the truth only, and nothing but the truth, so help me God. E mihi tēnā, kia tātou e taunei, tēnā koe te reo tangi o Uepohatu, tēnā tātou ngā toenga o ngā konohi ora o rātou mā kua mene. Tēnā tātou i o tātou mate kei tua o te ārai, tēnei i tēnei rā whakahirahira. Whakatōpuhia mai rātou, hei tautoko ki raro i ngā papatipu o Uepohatu, me te papatipu o te ngaere o Uepohatu, me tōna rohe o Māui mua. Mai ngā kuria pārei ki tihirau, ki whanaokena, ki mataahu, ki rangi kōhua, ki hairini, ki taumata pātiti, ki ngā waia tamarere, ki kerenu huahua, ki ngā mānia o te mana o turanga, ki te huka tai, ki te ranganui o toi, ki ngā maunga hirahira. Ka whakaoti atu ki te maunga tapu, ki te maunga ohikurangi. Tūtonu mai, te toka ahuru, te toka tapu. Tautoko, no reira, kia piki te ora, kia tātou. I am a claimant in the Way 129 and Way 222 claims before the Waitangi Tribunal. 2. I am giving evidence in this airing of grievances hearing, not necessarily because I agree that the process of hearing is something acceptable to me, but rather so that certain pressing current and long-standing issues of a fundamental nature concerning Ruawaipu and Uepohatu and be found upon and will be found upon a public record. Number 3, my preference would have been for full hearings before the Waitangi Tribunal, where I have not only been a claimant but also given evidence in the Turanga inquiry and the inquiry on the foreshore and seabed, and in both inquiries I was vindicated, with others in the findings and recommendations of the tribunal. The denial of tribunal hearings has meant that many East Coast whānau, hapu, iwi and tangata whenua have been denied, in my opinion, a reasonable chance to fully place in evidence and thereby articulate their claims with the help of counsel against the Crown. Instead, the claimant community has been railroaded into a settlement by way of the Ngati Porou Settlement Act 2012. Number 5. In December 2007, the Luna o Ngati Porou Chomp submitted a deed of mandate to the Office of Treaty Settlement to represent the Ngati Porou people in negotiations with the Crown for the comprehensive settlement of all of the historical treaty of Waitangi claims of Ngati Porou. This started a whole chain of events which led to the 2012 settlement legislation. 6. The mandate originally obtained was only from members of Trump, not from those who claimed not to be represented by Trump, and in that regard the mandate was flawed to the extent that it could at most only represent Ngati Porou interests and not, for instance, represent Ngati Rawaipu and Ngati Uepohatu in their historical claims against the Crown in a negotiated settlement. It does not matter what people like Apirana Mahuika and his son Matanuku say about the settlement being for all. It was foisted upon the many by the few, and those few have personally profited from it with jobs, economic power, and political favour. It necessarily follows, therefore, that in the Crown permitting iwi and hapu of the East Coast to be subsumed by a Ngati Porou entity, the settlement legislation amounts in itself to a prejudice, and is clearly inconsistent with the partnership principle of treaty, in that the Crown has in effect elected to disenfranchise Uepohatu and Uepohatu in their treaty relationships with the Crown. I venture to suggest that the same is true for other hapu I am able to whakapapa to, including Hauiti and Ngati Porou. And when such damage is done, it is hard to repair. 8. Definitions for hapu and iwi are to be historically contextualized by recalling, for instance, that the contemporary iwi model is a modern construct and bears no resemblance to the traditional Maori iwi. While I believe in a modern world to provide convenience, I look to my ancestors in Tikanga to provide my values, and in that regard, the settlement legislation is about utility and money. It does not have a heart and soul that reaches out to the tangata whenua. It mocks the people it is supposed to support, and enriches the oligarchy of Ngati Porou kupapa. Number 9. The Crown has denied the identity of traditional hapu and iwi through its settlement legislation. It passed law and sponsors a view that ignores the multifaceted nature of the overall tribal tapestry. The Crown's disgenerous approach has been, on the one hand, not to be involved in tribal definitions, thereby feigning deference to Tikanga. Yet on the other hand, to ram through legislation which denies any definitions are offered that will provide the full and true picture, and the Ngati Porou legislation is the best example of that to date. Ngati Porou legislation is the best example of that to date. Number 10. Importantly, the settlement legislation has prejudicially affected non-Ngati Porou East Coast iwi and hapu descendants by omitting their recognition, thereby limiting their entitlement to effectively exercise their own tino rangatiratanga in a meaningful manner. 11. Only the individual tribes can exercise tino rangatiratanga in terms of the Treaty of Waitangi, and whilst accepting that Ngati Porou is an iwi in its own right, the reality that belies its reputed omnipresence on the East Coast may be put into the correct perspective by reference to the Maori fisheries case decision on preliminary questions remitted by Privy Council, where it has been said by a court. Larger groupings such as Ngati Porou and Ngati Kahungunu were a conceptualization of common kinship at a high level of genealogy rather than regularly functioning social structures. Number 12. The concerns of Ruawaipu and Uepohatu in the past settlement world cannot be brushed aside of simply dismissed as the tumblings of a disaffected few. In reality, the hapu speak for many hapu and iwi all throughout the motu, which find themselves in a similar position. Unfortunately, the Crown's bargain with Mephisto has been to trade treaty obligation and honour for false promise that full and final treaty settlements can be reached by a sprint to the finish line dressed in a one-size-fits-all outfits. Number 13. The view that all tangata whenua within Portuguese to Te Toka Ataia are putatively linked by whakapapa with a Ngati Porou connection resolves nothing. Only the individual tribes like Ruawaipu and Uepohatu can exercise tino rangatiratanga in terms of the Treaty of Waitangi. 14. Why the Crown is so blinkered and committed to its forced assimilation strategy is because it does not have time to sort through hundreds or if not thousands of relationships with Hapu and Iwi that make up the real numbers in tribal landscape nationally and on the East Coast. This stratagem is clear. The Crown has refused on the East Coast to negotiate with the constituent Iwi like Ruawaipu and Uepohatu. 15. It is about the Crown being inexorably drawn back into the attitude of colonization. Worse still, not only is the Crown repeating mistakes of the past, but also repeating them such that damage done this time is greater. Indeed, the inexorable path seems to be dangerously close to cultural genocide, generally in the case where smaller iwi or hapu have been denied their treaty relationship with the Crown. Ngati Porou does not represent us, we represent ourselves. 16. Article 8 of the United Nations Declaration on the Rights of Indigenous People seeks to prohibit forced assimilation or destination of their culture, and that states shall provide effective mechanisms for prevention of any form of forced assimilation. Quite clearly, the settlement legislation first scheduled seeks legally to extinguish the existence of Uepohatu as Hapu of Ngati Porou. When that is factually untrue, that fact, Uepohatu is not part of Ngati Porou and never has been, is a part of my sworn evidence today. 17. Article 8 reads, Indigenous peoples and individuals have the right not to be subjected to forced assimilation or destruction of their culture. Indeed, the Crown's position on Uepohatu in this context has succeeded in excluding them from the prospect of a real settlement with the Crown by defining them as who they are not. Uepohatu have not properly consulted, and the settlement as it stands and is so fundamentally flawed as to be valueless for them, and the purported inclusion of our Uepohatu in the settlement legislation through the definition raised relied on makes a mockery of both tikanga and the treaty relationship. It is so scandalous as it is tragic. 19. What I say is not new. It has been recognized in tikanga for centuries and by the Maori Land Court for 100 years that the greatest in interest in the Kautuku block, Mangaroa, about 10,000 acres, and on the southern boundary of the rohe of Ruawaipu Waiapu Minute Book, books 53, 54 and 55, are based on the Papatupu or Ruawaipu Ngati Porou has no connection of mana to that land, and such connections that are said to exist by whenua of that land who descend from Uepohatu. Indeed, she predates Prodangi by at least 2 centuries. Turning now to the airing grievances hearings regarding procedural fairness as invited participants. That is, in these hearings, the participants should have been entitled to have counsel present. Counsel presence was not only directed to the procedure of our substantial matters in the hearing, but also related to other natural justice rights, including time to prepare, the preparation of the evidence to be presented, and the scrutiny of the draft evidence by counsel, all of which is to prevent prejudice to the participants. The right to procedural fairness in terms of Section 27 of the NZBORA has recently been affirmed and elaborated on in the US versus .com by Winkleman, JCIV 2012 404 1326. In the area of grievances hearings, there are no protections for participants procedurally or otherwise. 21. OTS should have paid for the presence of counsel at hearings, or at least the preparation for hearing, to ensure that procedural fairness was achieved for the participant, so that we would not be prejudiced in what we present, and especially so because the recipient party is the Crown. Anything said by the participants can, in theory, be used against those same participants if the Crown so elects. In conclusion, 22, I stand here face to face with you, knowing your intelligence, Mr. Minister, understanding your innocence and your vulnerability, the lies, mischief, and misdirection of all sorts presented to you by the contemporary Iwi Ngatiporou, which created the corporate company called the Runanga o Ngati Porou, and formerly the Haiata o Ngati Porou, and formerly the Runanga o Ngati Porou Trump of Ngati Porou. 23. For 25 years plus, the corporate company of the Runanga o Ngati Porou Trump planned, strategized, schemed, and mandated vulnerable members of traditional tribes of Ngati Uepohatu, Ngati Ruawaipu, and Teitanga Ahauti. They were supposed to facilitate the Ohukai water fisheries of the Tairāwhiti. They ignored the traditional tribes and received lucrative payouts of fish assets of up to $1 million annually, and pocketed approximately $25 million up until now. That said, without a razu coming to us, who are the traditional tribes. Number 24. For all this time, they have managed to sweet talk you and convince you and your Crown Company and your government this year to steal, award, and settle Ngati Uepohatu mana whenua, supreme land title absolute extent to the corporate company of the Runanga o Ngati Porou, which is not a live person that can inherit and possess a Maori whakapapa, and therefore cannot possess a supreme land title, ancestral inherited lands of the tipuna called Uepohatu, or any other Maori natural person tipuna. Number 25. In so saying, therefore, the corporate company of Runanga o Ngati Porou cannot inherit or hold tipuna Uepohatu land title. Such action is invalid, unsubstantiated, and mathematically amounts to theft of proprietary land rights at the highest degree of theft of a land title. Number 26. Now that it has been explained to you, then you now know that you have awarded stolen and settled to the wrong entity. Therefore, I am of the opinion that the funds for $132 million gained wrongly with Ngati Uepohatu proprietary rights assets should be paid directly to Ngati Uepohatu and not to the corporate company of the Runanui or Ngati Porou wrong entity. 27. Having said this, it is not the first time that you and your OTS and your Crown Company have settled wrongly. Number 28. The first OTS wrong settlement of the theft awarded to the Runanga o Ngaitahu Corporate Company over the proprietary title rights and $170 million that were owned by the South Island traditional iwi of Waitaha under the paramount chief to Hawaii. Number 29, the corporate company of the Runanga o Ngaitahu contemporary entity originated from Whangara, from down the road from here, and from the eponym of Tahu Pōtiki, who was the younger brother of Porou of the corporate company of the Runanui o Ngati Porou. As a result, the Waitaha traditional iwi of the South Island and its adjacent surrounding peoples became landless. They lost 45 million acres of supreme title rights, titled lands, and all that were left are the songs of Waitaha, memories of bygone days, and broken people who wearily sit and will loudly and will wail loudly as they retell their past, history and loss. They speak to records and whakapapa desperately and hope that one day they may retrieve land title which is rightly theirs. 30. In this regard, Ngati Uepohatu abhor the thought that maybe we could be like the people of Waitaha, beaten down like animals. Further OTS settlements were also recently wrongfully adjudicated, stolen, awarded and settled by you and your Crown Company and your 121 parliamentarians for rongo whakaata, whānau kai, te whānau a te koti, Wipere Trust and Kaiputahi corporate companies. Number 31. The above entire land titles belonged rightly to Te Papatipu o Te Ngaire o Uepohatu, as recorded in the Papatipu books and within the Uepohatu DVD of the Rohe, or the original traditional territorial boundary of Ngati Uepohatu. 32. The excerpts of the boundary of Uepohatu shall be presented by our next Uepohatu submitter for the validation of the tūranga for Gisborne territory which you have settled wrongly to the named corporate entities of your recent settlements. 33. To summarize explicitly, those settlements were the entire lands which not only belonged to the Papatipu o Te Ngaire o Uepohatu as were recorded in the Papatipu books. It started with the plains of Ormania of Gisborne, the ranges of Tangiharetanga, block of Ihaya Pātutahi, and the vicinity of blocks 1 to 8 of the Keredu Huahua and Mangatu area to Hikurangi Mountain. Then the beginning from Awapuni to Waipawa River began the tūranga or Gisborne blocks A to G of the lands of Patuwaidua of Ngāti Maru of Uepohatu. The Waiapu Minute Book number 7 recorded that. The mana o tūranga or the authority of Gisborne belonged to the Patuwaidua and went to the Mimiopawa of Ngāti Maru, who inherited the patu called Patuwaidua, the ear pendant called the Motoi, and the Tahahinu calabash or Huahua of Keredu Huahua. His tohu came to my great-grandfather Mimiopawa, and today I have inherited the authority or the mana o tūranga with replica of the Patuwaidua. 34. The above history was related in the Maori language to Judge Joseph Victor Williams and his Waitangi hearing at Gisborne. All have been ignored, and you and OTS and the Crown Company have awarded, stolen, and settled Ngati Uepohatu lands wrongly, and wrong entities of corporate companies instead, and given financial payments as well. 25. Ngati Uepohatu has suffered by yours, by OTS, and the Crown Company actions of theft, and our grievances shall not cease until all our proprietary rights, titles, and assets are returned to us, and we are fully compensated for suffering and humiliation. Number 36. All the above grantees of rongo whakaata whanau kai, te whanau a te iwi o te kochi, te whanau a wipere, and ira kai putahi are all corporate companies who cannot whakapapa to the ancient traditional ancestor of Maui Mua and 22 generations to Uepohatu, and to the 11 recorded children of the eponymous paramount chief called Uepohatu, chieftain called Uepohatu. Number 37, I descend from the Tuakana senior and eldest child called Rako Manohe, and the third child called Kari of Uepohatu. From these ancestors, I am able to inherit my mana whenua, supreme land, absolute extent, title to lands of my ancestor Uepohatu. 38. With you stealing, awarding, and wrongly alienating, and settling by your parliament votes and statutes, my rights to the corporate company called Te Runanga o Ngati Porou, you are denying me of my ancestral inherited whakapapa, my entity, my history, my indigenous native Maori titled land rights. Mr. Minister, after hearing these grievances, I pray that you would see natural justice and do the right thing of extinguishing the settlements to the corporate company of the Runanga Ngati Porou. Otherwise, we shall proceed to the International United Nations Organization Forum to complain of your breaches of our human rights under the Declaration on the Rights of Indigenous Peoples, in particular Article 25, where we as Uepohatu Indigenous peoples have rights to maintain and strengthen our distinctive spiritual relationship with our traditionally owned or otherwise occupied and used land territories, waters which we own, and coastal seas and other resources, and to uphold responsibilities and ownership to future generations in this regard. 40. Article 28. Uepohatu as indigenous have the right to our lands, territories and resources which we have traditionally owned, occupied or otherwise used or acquired. You shall give legal recognition and protection to these lands, territories and resources, and have due respect to our customs, traditions and land tenure systems of Uepohatu indigenous peoples, not to come and award, steal and settle with corporate companies that do not have a traditional whakapapa and credentials. 41. Article 28 gives Uepohatu indigenous people the right to redress by means that can include restitution or just, fair and equitable compensation for confiscated lands and resources taken without our free, prior and informed consent. Number 42, but worst of all, your Crown Company militia colluded with Ngati Porou, Kupapa, and tortured, murdered, beheaded, and staked heads of 168 innocent women and children and 20 elderly, naked, stripped old men at Ngatapa, at the back here, in the vicinity of the Mana o Tūranga. at the fortified pa of Ngati Madu of Uepohatu. Luckily, present was an eyewitness called Dr. Ruskin, who was a colonial assessor. He recorded everything and tried to publish in New Zealand, but was disallowed. He returned to Britain and tried to publish the atrocities of the Holocaust there, but was also disallowed. He then sent a copy of his manuscript to Tamate Kapua Poata of Tokomaru Bay, a human rights fighter, and when he read about my researches, he sent me his manuscript, which he called Te Aureretanga. 2 weeks after he died. I brought it to show you, included in the book, are horrendous excerpts of other misdeeds of Holocaust by the Crown Company militia and Ngati Porou. 43. That there is a precise recording of the bloody actions of the Ngati Porou with whom you have associated to create havoc to Uepohatu. There were flawed mandated records of their dead people and vulnerable traditional members of Ruawaipu, Hauiti, and some Uepohatu who lived in hope that would be dealt with a good financial deal in the near future. You, the Crown Company, and the government assisted them financially with millions of dollars and thousands of dollars to get mandating from Australia and other places throughout New Zealand to get them to Waitangi tribunal hearings and to aid them in their advertisements and propaganda. The company was assisted by the Crown Company in every way to catch Uepohatu and the other traditional iwi unprepared. There were army strategists like Wira Gardner and Monty Suter who came and played politics with our simple minds in the hope that we would agree to give them our traditional rights, but we never sold them anything. So Apirana Mahuika recorded within the Papatupu books that are about authority. Authority means mana. The mana of the land, mana of the oceans, the mana of the sacred places, the mana of the person went to Uepohatu before the arrival of Toikei Rako, the Kuru peoples, and the Prourangi of Ngati Porou peoples. 44. The Uepohatu Whakapapa began with the demigod Maui Mua, paramount chief lineage and senior of all whakapapa in the entire Tairāwhiti territorial boundary, as the next Uepohatu submitters shall cover. The whakapapa is paramount, and you must understand that no matter how much you try to take away Uepohatu identity, history, authority, and award them to another, you cannot, because the land was in extant forever. 45. I, Ariki Nui Tapairu Ngaka Waingarangi, Prime Minister commissioned by the Sovereign Confederation of Chiefs of Tribes under the 1835 Declaration of Aotearoa New Zealand Independence, aka Sue Nikora, the Hui Nikora, the Hui do give sovereign notice to you, Honourable Chris Finlayson, Attorney General, to extinguish your wrong settlements that you, as Minister of OTS, has awarded, stolen and settled Uepohatu indigenous, ancestral, supreme, absolute lands title extant to a Runanganui or Ngati Porou, a corporate company which does not possess a whakapapa and does not possess a supreme title or land. The $132 million which you are contemplating giving the corporate company, you need to forward to Uepohatu for compensation for suffering and humiliation. 46. Failing this sovereign demand, you shall be taken to the International United Nations Organization Court for breaches of our human rights of indigenous status, to the Hague before the War Tribunal to answer allegations of Holocaust for murders of our ancestors and worst of all, to allege committing of treason against the sovereign confederation of chiefs of tribes of Aotearoa, New Zealand, which is recognised by the international community. Ariki nui tapaeru ngaka waingarangi, aka Sue Hui Nikora, Wai 129 and Wai 222. Ariki nui tapaeru ngaka waingarangi, Prime Minister, Sovereign Maori Government of Aotearoa, New Zealand. No reira, tēnā tātou.